You should have all picked up your exams by now.
I noticed online where it says you can look at the A+ answer in the exam. It's from fall of 2015.
Did I upload the wrong one? Oh, I'm sorry about that. Okay, I'll fix that. Actually, you know what? Shows how often people clean up. These are actually still here from Friday, so I'll put the correct one online later. And if I don't completely go through mine, but you can just pass it around. And if anyone who didn't get the A+ answer, my mistake, I linked to the wrong file. I'm sorry about that. Blogging error, I suppose. If you haven't already picked up your exam, you ought to. The reason why is these are for your benefit. If you got a C- or lower, you are required to come meet with me. Don't think you can hide. I know who you are. I have all the names now. So if you don't email me, I will email you and schedule a time. These are for your convenience. For everyone else, you're welcome to come meet with me, but I want to give priority to people who got the lower grades because they need the attention first. But I will promise if anyone wants to meet with me to go over your exam, I will make the time to do it. It may take a while because I have 160 students a semester. Don't think I'm ducking you, but just there's a lot of people who all want to ask the exact same question. But I will make a time for whoever needs it. Okay. Any questions about the exam or the midterm or anything else? Anything on your minds? Yes, sir. No. That's what, if you want comments, you come talk to me. I gave you the letter grade, but there are no comments, no. Other questions? All right. Yes, ma'am.
This is Matt. So, teacher, did you have a rubric as you're going through the exam of things that you're looking for?
Kind of, yeah. So each question, I think I mentioned this, but each question, there are 5 questions, and each question is worth 10 points. I grade each question scale of 1 to 10, which makes it very easy. So a perfect paper is worth 50 points. In terms of where you start getting credit, if you just give me, an answer somewhere in the ballpark, that's probably worth 5 or 6 points. The 7 to 8 point range is where you start actually citing cases and you start applying the cases. The 8 to 9 point range is where you're giving me not only the cases, but you're also giving me various policy arguments. And the 10s are very rare. I don't give out a lot of 10s. That's an answer that absolutely blows me away. And it's like, wow, this person really gets it. So if you're generally speaking in the ballpark, you'll get half credit, and that gets you to roughly, a C, all 5s. There were some people who did worse than that, meaning that their answers weren't even in the ballpark. They were just, somewhere else. But for the most part, if you look at the distribution, virtually everyone got more or less in the ballpark. I will note that I grade the midterm more strictly than I do the final because I want to scare you. And I don't mean that in a mean way, but I want to light a fire under your belly to inspire you to do greater. In the past, I've graded the midterm perhaps more generously than I should have, and people got complacent. So I'm not doing that this semester. So there's room to grow because the curve was lower than it would have been for the final exam. It's just the curve, I think, was a 2.9. Usually my curve's over a 3 for the final. Excuse me. To answer your question? Yes.
Just curious, you said ballpark, citing cases, and policy. So what would blow you away?
Well, if you look at the A+ exam that I just gave you, yeah, I mean, it's relatively speaking blowing away, right? But to really tell me that you understand the nuances of class discussion, you understand the why. Why is a rule the way it is? The what. If you tell me the what, you get yourself a 6, 7, or 8. If you tell me the why, you get a 9. If you really hit it home, you get a 10. I've never given 100. It's never happened yet in all the years I've been teaching. So maybe someone may get 1 or, the top paper may get a couple 10s and the rest are 9s. So these are very rare to hand out.
Whenever I went onto the website to see like the test and the A+ exam, I think you had to Prop 2.
So she already said that.
I got your link. So what you later?
Yeah, I said I'll fix it. I said I'll fix it. And I'm passing around. I don't think I'm going to have enough, but I'm passing around whatever ones were left over from class on Friday. If you got one last week, don't take another one, please. So that way our late coming friends will be able to see it. I saw another hand somewhere.
So, just to be clear, the first question was, give me the strongest argument. And is it safe to say you want us to show you why we chose that argument to be the strongest? That's the last like portion. Like we didn't choose the rule of labor theory because the other party has a strong argument. That's why I chose this. Because that was my reasoning.
Yes.
Why I chose
Yeah.
to be close, but I didn't put that in my argument.
Well, yes. The more you give me, the better. The more why you chose what you did, that's better an answer. There's no one right answer. When I say the students go crazy, I don't have an answer in mind. I mean, if you look at the, say, whether 7 or 8 papers I got an A, they were totally different things. I don't have a set answer in mind. I'm looking for your reasoning, and on each question, one at a time. But I'm glad you're asking me these questions now, so that way, come May, when you sit for your final, you're not, in the dark. You have some sense of what I'm looking for. That's why, as much as I feel that the students don't really prepare enough for these midterms, and I'm convinced they probably don't, the fact that they're asking these questions at least puts you in a better place than you would otherwise be if it's not there. So, on average, it's probably, you should be studying for it more, but it's serving its purpose.
How much do you lose if you say like the jewel thief case instead of actually?
I mean, you're not going to lose points, but that's not going to blow me away, right? I'll know the jewel thief case, but it doesn't really hurt you to say armory. It's actually fewer words, right? I mean, it's not the Fox case, Pearson. I mean, if when your lawyer is one day and you're citing a case to a court, you're not going to say the Fox case. You're going to say Pearson v. Post. You're going to. I suspect you're being burdened with an entire citation manual of how to cite cases, not like parentheses Fox case. Yeah, get into a habit. It's good. Yeah, it's a funny thing though. People really object to the word limit. You realize every brief you'll ever write in your entire life is a word limit. Every brief you'll ever write. I mean, just to give you an example, a brief to the U.S. Supreme Court, a certiorari stage brief, is 7,000 words. You have 2,000 words, right? You have 2,000 words for whatever random stupid question asked versus a Supreme Court brief is like 7,000 words. Just to get a sense of proportion, right? It's actually a fairly generous space if you actually think about what you'll have to do in a couple of years. Okay, other questions? All right, let's start. So we finished our unit last week on co-ownership. And we discussed these 3 kinds of co-tenancies. There was the tenants in common, there was the joint tenancy, and the tenancy by the entirety. And the last 2, the joint tenancy and the tenancy by the entirety, were a special species. You'll recall the joint tenancies, there are these 4 unities that must be present at all time: time, title, interest, and the possession. The tenancy by the entirety was like a joint tenancy with a 5th unity, that is marriage. They shared one very important thing in common, which was the right of survivorship, that when joint tenant A died, it went to joint tenant B in fee simple. Similarly, when spouse A died, it goes to spouse B in fee simple. Fine. But there's an important distinction between the joint tenancy and the tenancy by the entirety, which we didn't go into too deeply, but becomes much more relevant for our discussion today. And that is how the joint tenants or the married couple own the property. So we said with the joint tenants that each party has a separate but undivided interest. That is, each of them has access to the entire property, but they have a separate interest among them. It works very differently for the tenancy by the entirety. With the tenancy by the entirety, there are no separate interests. The husband and the wife, or the husband and the husband, or the wife and the wife, whatever it may be, indeed own the property together. There is only one interest among the 2 of them. There aren't separate interests for the husband and wife. And the reason why this is the case is a factor of history. Again, we go back to the Middle Ages. You thought we were done with that stuff, but not quite. And this is the introduction to our next couple classes on marital property. You will take an entire bar class on marital property. I won't even pretend to tell you everything you're going to need to know about marital property. You will take professors who know this much more than me. But what you do need to know for this class is how marital property intersects with real property, right? How the joint ownership of land by husband and wife is impacted by the rules of property. That's what you need to know for here. There's lots of other rules about divorce and custody. You'll do that in a different class, but this class is a very narrow focus. Oh, I wanted to remind you, there's an event today at 11. The South Texas Federal Society is holding an event on how the Supreme Court works. The guest speaker will be Justice Brett Busby from the 14th Court of Appeals. He's a very good friend of mine. I'll be introducing him. Justice Busby clerked in the U.S. Supreme Court for Justice White and for Justice Stevens. He'll be giving a discussion of how the Supreme Court works, nuts and bolts stuff. It's today at 11 on the library on the 6th floor, and there's going to be free barbecue. So I strongly encourage you to attend for your common law lessons. This will be very useful. You'll learn a lot from Justice Busby. And whatever questions you have about the Supreme Court, you can ask him. So it's basically immediately after this class at 11 in the library on the 6th floor. And I'll be there to introduce him. Okay? Sorry, I meant to mention that at the outset, but I forgot. Okay, so any question before we get started now? That was all review, nothing new. So we have two different types of marital property regimes in the United States. We have two different types of marital property regimes. The first type is what's known as a common law property. And the second type is what's known as community property. We'll be doing community property next week. That is the regime in effect in Texas and a number of other southern states. So don't ask me about community property today. We'll get to it next week. Today and on Thursday, we'll be talking about common law marital property. Common law marital property. So at the outset, I want to make one point very clear, and this is something which always confuses students. Virtually everything we're going to be talking about today about how marital property is divided only matters after a death or divorce, okay? In the same sense that when you're a joint tenant and person A owns, say, 60% share and person B owns a 40% share, during that joint tenancy, none of those numbers matter. You only care about those numbers when there's a forced sale or a partition or something to that effect. Similarly, with marital property, almost none of this stuff matters while the husband and wife, or I'll just say husband and wife to make it easier, but whatever the arrangement happens to be, are married. When there's a divorce or perhaps a death, that's when it gets complicated. Okay? So just keep this in mind, that these things usually only come into play when there's a divorce or a death. During the marriage, the actual shares of ownership don't really matter too much. Okay? So now I'm going to lecture a little bit because the history of this is somewhat tedious, but I'll try to make it as enjoyable as I can. So the common law property system evolved mostly in England as a consequence of feudalism. You'll recall the doctrine of primogeniture was premised on the notion that land should be inherited by the oldest male born. There were perhaps misogynistic reasons for this, but there were also practical reasons for this. It made it very easy when property was held by one person and you didn't have to try and divide it up among, 8 kids and who has this share and who has this share, right? There was a utilitarian purpose of primogeniture, which was to make things easy. As an extension of primogeniture was the doctrine of what became known as coverture. Let me write these words out for you. Coverture. Okay. What does coverture mean? When a man married a woman, the woman was actually placed under the cover of the man. That's where the phrase comes from, coverture. When a man and woman got married, the woman was legally placed under the cover of the man. And a legal fiction was created. What do I mean by a legal fiction? The man and woman were now viewed as a separate entity. It was almost like a third person, right? Right? Long before like Brangelina or whatever, right? You have two people who come together and they form an independent entity. Whatever property the woman had before she was married, and again, women could inherit property. They couldn't actually acquire it, but women could inherit property. Whatever property the woman may have had before the marriage is now covered, is now put under this umbrella of coverture. Okay? So the fiction was that the husband and wife had, this unique personage that could jointly manage all of their property held together. But it was a fiction. And the reason why it was a fiction is that the husband had complete and total control over the property. The wife had no legal say over what happened to property under coverture. Zero. Indeed, until fairly recently, women could not even earn wages. Women could not engage in contracts. They couldn't engage in the transfer of land. So even if, in theory at least, the husband and wife had this, this joint personage of coverture by which they could manage property, in reality, the women had absolutely no say whatsoever in how the land was used. The only way that this coverture perhaps benefited the woman, and I say that lightly, is that if the husband died, the coverture disappeared. And whatever land was held jointly by the husband and wife is now given to the wife as a right of survivorship. Okay? So imagine this, right? Before she gets married, Jane has Blackacre. Jane gets married. Blackacre is now held under this coverture that the husband can manage completely. Husband dies. The coverture disappears, and then Blackacre once again is owned by Jane in her own personal capacity.
If the husband owned property, whenever that unity happened, and then the husband died, would the wife get survivorship of the land? Or
Not necessarily.
the heirs?
Not necessarily. It would depend on how the property was titled. If it was a joint tenancy, then the wife would get as a survivorship. If the husband held it in fee simple and he said, I hold it for me and that's my firstborn son, then the son would get it. So not necessarily.
So joint tenancy or tenancy by the entirety, wife would get survivorship.
But it was not titled as such. After the husband dies, it goes to whoever the heirs are.
And so if he had it as fee simple, it goes to heirs. Okay.
More likely than not, yes. Right, so in that sense, at least, whatever property the wife had before the marriage, if the husband dies or if there's divorce, divorces were very rare. But if there was a death or a divorce, then it goes on to coverture, and then it goes back to the wife as an independent person. But there's no guarantee that Blackacre will remain within the marital household. What if the wife owns Blackacre to start? They get married, they have coverture, and the husband decides, I'm going to sell Blackacre. Blackacre sold, the husband pockets the money. The wife gets nothing for it. So there was no guarantee that whatever property the wife had going into the marriage will still be there on the way out.
sorry, maybe I'm misunderstanding. So let's say a woman has property comes into the marriage and then the man divorces her. Are you saying that she gets it back? It just seems like back then they wouldn't have wanted that. They weren't very.
So the answer is how did she gain the property? If she inherited that property and it's hers and hers alone, then yes, she would. Cool. Right. But that was again fairly rare because most property was not inherited to women. It would be the rare case that a woman would actually inherit property in fee simple in her own right. Yeah, more often than not, this applies to like, you know, jewelry. I think they call it paraphernalia, right? Jewelry and various personal effects. Those are usually the extent of a woman's property because it was very rare. I stress this, very rare that women would actually inherit Blackacre, but in theory at least, right? In theory at least she would get it. Okay.
Like, does when you're in that situation when she inherits property, does it matter if she, for whatever reason, inherited property before or during the marriage?
So it's interesting, right? Is even if she inherits property during the marriage, okay, it's still marked for her. So if the husband dies, property she inherited during the marriage would go back to her. But while they're married, and this is an important point to stress, while they're married, the husband exercises complete control, and he can then sell off whatever she inherits. So I mean, it only again matters after a death or divorce the wife actually sees her property again. A single woman, even at common law, could engage in certain types of transactions, but a married woman was consumed by this coverture arrangement. Okay. I want to briefly contrast the common law approach with the community property, which we'll study next week. The community property, which evolved on the European continent, Spain and France and elsewhere, was premised on all the assets being shared equally. Right? This wasn't this idea of coverture. This was the notion that you share the assets equally, and that if there actually is divorce, you divide the assets equally. This is where we have what's known as division of assets, which we, now all states have, whether common law or community. But the idea of actually dividing up assets developed in this continental community system. Okay, so everyone with me so far? Any questions on that? No? All right, we'll move on. All right, so what exactly then did the women get out of this coverture system, right? They were supposed to be getting support during life, okay? That is, during the extent of the marriage, the husband agreed to an obligation to support the wife, which generally meant food, clothing, shelter, and that's about it. This was the arrangement of how things worked. Right at the moment of their marriage, the woman moved under their husband's cover, and the woman actually ceased to be a person, at least for legal purposes, for the duration of the marriage. Okay. And the wife's obligation was generally viewed as what we may call today home ec, right? The managing the home, managing the children, and any other household duties. Okay. Everyone with me so far? Okay. So the biggest changes, the biggest revolution in marital property occurred in light of debt collection. I think I mentioned this last week. Debt collection was the greatest shift in how states treated women for purposes of marriage. So let's use an example, right? Under the common law, right? Under the common law, with this doctrine of coverture, even though in theory at least there's this fiction that the husband and wife owned it together, for purposes of the law, the husband had 100% control over all the real property, 100% control. So what happens if the husband then gets into debt? Right? I'll start going around. Where did I finish last time? Do you remember? Are you pointing at yourself? So you're next? Okay, Samantha. So Samantha, let me ask you this question, right? Under this common law legal fiction of coverture, the husband gets into a debt and he doesn't pay his debt. Can a creditor try to seize land that he holds jointly with his wife? Under the common law, think about it for a second.
Under the common law, because they technically own it. So he has complete control,
Yes.
but they own it entirely together.
Under this coverture arrangement, right? So what do you think?
No,
Well, why do you say no?
because they technically own it entirely together.
Well, technically, but does a wife have any say?
No, so then they can take it all.
Okay, she's right. Under the common law, right? This is why we have this Sawada case, which is kind of complicated. But under the common law, with this coverture arrangement, the husband, for all practical purposes, was the 100% of the owner. The wife had no interest other than her survivorship right. Right? She had her survivorship right, but that's it. Again, only when someone dies or gets divorced does the wife's interest ever come into play. So creditors were actually able to seize the land, subject to survivorship right, to satisfy a debt. Okay. This was viewed as very harmful, right? No one likes their property being seized by creditors. So starting in the 1830s, a move was pushed forward to start granting women property rights. Now, we can view this somewhat critically for a moment. The impetus, right, the motivation for these sorts of laws was not for women's rights and for equality. Be very clear. The motivation for these laws was to shield husbands who got into debt. It was to shield husbands from debt collectors. That's why these laws came into existence. I think what the book said in 1839, the first Married Women's Property Act emerged in Mississippi. Right? This is not the most progressive state, with all respect to Mississippi. Right? They weren't doing this to promote women's equality. It actually happened after something known as the Panic of 1837, where there was this economic crisis and people's properties started to be attached. Okay, so the innovation of the Married Women's Property Act, the MWPA, which spread to other states, was that now coverture was still in effect. Right, the wife didn't actually have full legal personage, but she did now have a separate interest in Blackacre, a separate interest in the land. Okay? And as a consequence of this, she could refuse to sell the property. That was, think of the bundle of sticks, right? The only stick she had was that she could refuse to sell the property. She couldn't manage it herself. She couldn't sell her share. All she could do was block the sale of the land. Now, why was this important? Let's say a husband gets into debt and the creditor tries to force a sale of the land. Now, the wife can block the sale. The wife can say, wait a minute, my husband has his share, I have mine. You as a creditor can only reach his share. I'm not in debt. I never agreed to this contract. You can't reach mine. Therefore, I'm blocking the sale of the land. Okay? By this subtle change of giving the wife this stick, this ability to block the sale, they made it impossible for creditors to seize land that is jointly owned by the husband and wife. Now, you may say, well, that's not fair, right? It's not fair that the husband can get into all this debt and then the wife can just, block the sale. One of the points raised in the Sawada case is that if you're a creditor and you're giving a loan to a married man, you now know that his wife can block the sale. So by giving a credit, a loan to a married man who's using his property as, the basis, the collateral, you know that he can block the sale. So on the one hand, I suppose this makes things more fair, but on the other hand, it makes it harder for married people to get credit because they know the wife. Now, how could this be solved? The wife and the husband can sign the mortgage together, right? The wife and the husband can jointly agree to the debt. I'm not sure if in Mississippi the wife could even do such a thing in the 1830s, but in theory, at least, that's how it worked. Yes. Oh, I'm sorry. You sure? If it comes back to you, you can raise your hand. Okay. Even though these laws didn't emerge as tools of women's liberation, soon enough they developed closer to that fashion. So I've looked into this. So Texas, when it was still a republic in 1840, passed one of these such acts. It was the most expansive legislation in the South. And the Texas law actually allowed married women to enter into contracts, they could write wills, and they could actually sue for divorce. You may not think about this, but divorce at common law could only be initiated by the husband. So one of the revolutions of the Texas one was now women could actually petition for a divorce. Women could also veto the sale of property, blah, 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 and they could do different things. So some of these laws actually became quite significant. Do you remember?
Yeah, can the creditor sell the interest to someone else to get money at that time? And then whenever, if there's no survivorship.
Okay, good question, good question. So a creditor, a bank, right, can always sell their claim to someone else. So what they were hoping for, right, what happens if the wife dies first? The husband now owns it in fee simple, and then what can they do? They can seize the property. However, Joel, let me ask you the other question. What happens if the husband dies first and the wife gets it as a survivor? Can't touch it, right? So it's almost this weird game of life, right, where you're hoping that the husband, that the husband survives, because once the husband has a fee simple, then you can attach his assets.
If they put the claim before anyone dies, if they say we got to claim this property, then how can they turn it into the claim for now the whole fee simple if the wife dies?
Well, generally speaking, if you're in debt and you acquire new property after the judgment, the bank can go and say, oh, look, they just acquired this new property. I want to attach that instead. They're not actually trying to seize the land. They're trying to seize a debt of value X, whatever the debt is. So if someone inherits property, okay, you can attach that now. They're always trying to get the dollar amount. So, and this actually comes up in the Sawada case, the case we'll do in a couple of minutes, basically the husband survived the wife, right? And then he tried to, convey it to his kids to block the sale.
Earlier in our reading, it talked about how husbands would be responsible for the torts of the wife.
Yes.
And so if our case that we're about to read, if it had been the other way around, where the wife had done the car wreck, could the creditor have come after both the husband and wife, one as like
I see your
actual
point.
tort and one as responsible for the torts?
Yeah, so I think the doctrine of the husband being responsible for the wives, that disappeared a very long time ago, long before there were cars. But in theory, at least, if the wife had engaged in a tort, and then the husband would be responsible for the tort, then yeah, they could have gone after both of them. But it's almost a fiction because there is no wife, right? Under coverture, the wife legally didn't exist. It would only be after the husband. So even if the wife had engaged in a tort, it's as if the husband had did it. So there is no wife. Yeah, I mean that's the point.
Except to own her interest in land.
Yeah. During coverture, the wife legally did not exist. The person ceased to exist. I mean, it was as if there was no person there until there was a death or divorce. Then that person magically, reemerges from the shadows. Okay. A little bit more on women's suffrage. So one of the one of the most fundamental points in the women's rights movement was in 1848, a document known as a Declaration of Sentiments, which was written by Elizabeth Cady Stanton and others. And this was supposed to be sort of a declaration of independence for women, so to lay out various rights that women wanted. And what's interesting for purposes of this class is several of them were directly tied to issues of property. So this lists, much like our Declaration of Independence, a series of grievances that the women were charging. And one of them, and I'll read these, it says, he has made her, the woman, quote, if married in the eye of the law, civilly dead. Right? So for purposes of being married, the woman was effectively dead, like they didn't exist. The other one says, he has taken from her all right and property, even to the wages she earns. Because indeed, in states that allowed women to work, not all states did, very often the paycheck was given right to the husband. And another one I'll read, he said, he has so framed the laws of divorce as to which way the proper cause of divorce, blah, 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 to be wholly regardless of the happiness of the woman. So in other words, the husband was solely responsible for initiating divorce. And if he didn't, the wife was stuck. And during the life of the marriage, the wife really had no means of working on her own. So there was a very strong connection between the Married Women's Property Act, which again didn't start off at women's rights but became that later on, and the suffragist movement. And the 19th Amendment, just so you know, which gave women the franchise, wasn't ratified until 1920, roughly 50 years after the ratification of the 15th Amendment, which gave people the right to vote regardless of their skin color, though only for men. I tell this story in con law, but there was one election where Susan B. Anthony walked into a polling place and said, I want to vote. And the guy was like, you can't vote. And she said, well, she pulled out her Constitution, which we should all have in our pockets. And she said, the 14th Amendment says all persons are guaranteed equal protection. I'm a person. And the guy actually gave her a ballot. So she was able to vote. Although there was a later case involving women where the court basically said they're not covered. The 14th Amendment actually makes reference to male suffrage. So they needed a separate amendment to get there. Little history lesson for you. Yes, just keep on your bright. These come in handy, I promise. They'll win you a bar fight sooner or later. they come in handy. Questions? All right. There's a question on page 385. If you want to just flip to it in your book. I think, are you next, Lauren? I think you may be. Sure. Want to just read the question on page 385? Is a problem with the husband and the wife?
After having a stroke, H, anxious to avoid going into a nursing home or being cared for by professional nurses, entered into an agreement with W. H promised W that if W personally cared for him at home for the rest of his life, H would devise her certain property by will. In compliance with the agreement, W personally cared for H at home until his death. When he died, H devised the property promised to W to his daughter by a prior marriage. Can W enforce the contract?
What do you think there? What do you think? So we have a situation, right? Husband and wife. The husband says, "Oh, sweetie, I'm sick. If you care for me for the rest of my life, I'll give you all this property." And the wife lovingly cared for the husband, and then he disinherited her and gave it all to his daughter. So what do you think happens here, Lauren?
Is this under the Married Women's Property Act or just like
Well, let's say there's a Married Women's Property Act. But even so, husband and wife are allowed to have separate property, right? Even in a community state like Texas, the husband and wife are allowed to keep their property separate. They have to do some paperwork, but you can have husband and wife separate property. You're not required to own things jointly under the modern approach. What do you think happens here? Does the court enforce this promise and require the land to go to the wife? Consideration. Okay. So is this in fact a contract? Is the wife taking care of the husband a contract? You use a consideration word, right? Is that just like any other contract you form? Okay, Florence, what do you think?
There was a contract formed by the marriage, so there's no new consideration.
Oh, why do you say that? That's a good intuition. Why do you think that's?
They're supposed to clarify.
Ah,
Vice versa.
okay. What do you think, Carlos? Let's go through, see how we wind up.
Well,
Do you think Lauren's right? Do you think Florencio's right? What do you think?
I think there was a pre-existing legal duty to actually.
So the marriage imposed a pre-existing duty. Is that
when
your?
people get married, don't they agree to take care of each other's death?
Oh, okay. So now the vow was the contract, right? So both of you guys are right. So the court actually held here. This is a California Court of Appeals decision. What the court actually held here was that marriage imposed this duty of support and mutual obligation to each other. Right? The court said the wife, as a matter of marriage, right, was obligated to care for the husband. Okay? And in fact, they said the idea that a husband and wife would have to reach a contract to care for each other would be degrading for the wife, because it would basically make her a servant, that she's basically getting paid to take care of the husband through this sort of property arrangement. And the court says that the husband has an equal duty to care for the wife. It just happened in this case that the husband was ill and the wife was not. They said that this was, quote, antithetical to the institution of marriage.
I had a question about that because caring for your husband, sometimes they're so sick that maybe you physically can't even put them into a bathtub. You can't, like, caring for them might be putting them in a facility that can care for them better.
Ah,
and so in my mind, what does even caring for them even mean if physically you are unable to care for them anymore, if they're so, like, you know, almost hospital bed bound kind of thing.
Good. So there was a dissent. There was a dissent to this case, which made a very similar point that Sarah just said. Dissent said, look, this is an outmoded view of a relationship. The wife can choose to pay for the care, put him in a home, right, rather than providing for herself. The dissent also said that this agreement to care for the husband went above and beyond what the marriage vows required. In other words, the wife was not required to personally care for them. Right? And this penalizes wives who work at home. So what the court basically said was they're free to contract and to create additional arrangements above and beyond. Interesting. I mean, the point you made is almost exactly what the court said, that if they so choose, the wife can choose to pay for care. And there's no necessity, and indeed maybe it's not even feasible for them to provide personal care. Yes, very, very, you're right next in line, which is perfect. It doesn't script my order. Okay.
So
Yes, ma'am.
that would make the agreement unenforceable.
The dissent would have not enforced the agreement, but the majority opinion enforced it.
Oh, the majority would enforce it?
I'm sorry, I said it backwards. The majority opinion said the contract was unenforceable, but the dissent would have enforced it. I'm sorry, I flipped in my head. It's not contractual, but they effectively said that marriage imposes a duty. They phrased it as a mutual duty of obligation from one to the other, and that this additional contract is, you know, degrading of that initial arrangement.
So marriage contracts are not.
It's not a contract, though. I'm using that word loosely. They call it a mutual obligation that you basically, to use maybe Carlos's phrase, till death do you part. That you actually take on an oath to enforce this, but it's not something that the courts can police. Because, I'll get you a second, Jessica, the flip side to this is what happens if during marriage the husband or wife, whoever happens to be, does not care for the other spouse? Can they go get a court order saying, hey, he's not caring for me? And the short answer is no. After a divorce, courts will step in to award custody, to award spousal support, alimony as it was once called. But during marriage, for a court to order the husband to give the wife an allowance or something like that, you're not going to see that. Unless there's actually allegations of physical abuse, neglecting a person's financial well-being is not something the courts intervene.
I'm wondering if the same situation would have been faced by the husband and wife if the transfer would have been not by will, like he divides by will. So
Well, this actually wasn't by will though. This was a promise during life.
yeah, but it says property by will. So it says H who divides her certain property by will.
Oh, I see what you're saying. So he promised he would execute a document later, right?
Yes.
Right. The promise itself was made during life, but he promised he would write a will later.
Correct. So
Right.
I mean, it works different, right? If you promise to divide by will, there's like really nothing to enforce there.
Yeah, I mean,
There is no
on that front, you're right. If I say I promise that I will change my will next week, if I never do it, you can't make me, right? They're not going to rewrite a will. It's a very, very stringent formalities. So the wife should probably gotten in writing first. Although,
If she would have gotten the writing first, the written document first.
I mean, if she would have said, "Sweetie, you're going to change your will now, then I'll take care of you," then it would be a different story.
No, just transferring his.
Oh, transfer during life, you mean?
Yes.
Well, she could have extracted that up the front, but perhaps she didn't think of, putting to that test. But she could have absolutely said, "You can give it to me now." I'm sorry? You want to talk this way? Yeah. Yes.
Oh, I just remember a contract, so she was like detrimentally.
Estoppel, son?
By like foregoing medical school or law school, she could sue the state for.
There's no way under this majority opinion that would work because she has an obligation to care for her husband independent of whatever career aspiration she
There was
has.
a court case where a wife supported her husband through medical school, and he said he would support her.
We'll do a case like that later this semester. We'll do a case like that, I think maybe the next class, I can't remember which one it is, where the husband was getting his MBA and the wife was working, putting him through school. And shortly after the husband graduated, he asked for a divorce. And then the wife tried to recover the lifetime earnings of what the MBA would have added to the husband. And I won't spoil it, but you'll see how this case turns out. But that's a case we'll do in a week or so. Yeah, Norma.
Would this problem more about it being an oral contract and not a contract in writing? Is what Jessica just said.
The oral contracts are generally enforceable, but the court said that this specific contract is not enforceable because it goes against the policy of what marriage is.
But I mean, there's this thing as prenup. So
Which again is before the marriage, right? These contracts during the marriage, the court will not enforce. Pre means before, right? Prenuptial. You can arrange your property however you want before. What the court says here is during the marriage, this is your obligation. You can't contract around it. The dissent takes the other position. Yeah.
Is the majority view across the country or just California?
Well, this case is what year? 1993, right? I mean, it's not that old. So that's probably the view. Any other questions? People always like that example. It's always very counterintuitive, I'll say. Anything else? All right, you want to, okay, Carl, you're up next. You want to tell me what happened in the Sawada case, please?
In the Sawada case, we have the Samuel Endo got into an accident with the Sawadas on.
I think your name's maybe slightly, well, okay. Who?
Kokichi Endo.
Yeah, okay, I think that's right. Who was driving the car that got into the accident?
It was Kokichi Endo and Helen Sawada were involved in the accident.
Well, there were two people in the car that were at fault. Who were the two people in the car that were at fault?
Was it Kokichi Endo and her husband?
No. So the names are confusing you. So the actual people in the car, okay? You have Kokichi Endo was the father, okay? He struck the car with Masako Sawada and Helen Sawada, okay? Kokichi was the driver at fault. Okay, you got that?
Yes.
Okay, good. Then what happened after the accident?
After the accident, the Sawadas filed a suit. Helen Sawada specifically filed
Good.
a suit in June
Good.
of '69.
Good.
in July of '69, Endo conveyed a parcel of land to his children.
Okay, good.
And
Why did Kokichi Endo, the husband, transfer his land to his kids, Samuel and Toru?
probably to prevent the land from being taken in a lawsuit.
Very good. Okay. There's a very common practice in the law where if you're about to get sued or you've already been sued, you get rid of everything you own. That way, creditors can't come and seize your land. The reason for this is painfully obvious. In fact, it's often, I should say often, it happens that before a divorce, the spouse with more property will suddenly sell, all of his property at a very low price. Wait for the divorce to happen, wait for the division of assets, and then magically buy it back for the same price that he paid. These are transactions, which are meant to shield a person's assets from any sort of creditors. If you're sensing a pattern here, almost all of this entire topic is about hiding from creditors, if you're sensing a pattern, right? To guard against this, there's a doctrine in law known as fraudulent conveyance. Okay? What's a what's a fraudulent conveyance? What does that mean, fraudulent conveyance?
When you transfer the property to avoid having to pay off
Good.
the
And what are the consequences of a fraudulent conveyance? What can a court do in that case?
They can deem it invalid.
Exactly. So if a court finds that a conveyance of land or property, whatever, is fraudulent, the court can step in and cancel it. They can actually rescind the sale. They can set it aside. And the reason why they have this power, and it's a big power, is to deter parties from engaging in these illegal transactions to hide assets, right? Courts don't want people hiding their assets when a judgment comes along. So if you look at the chronology, which Carl mentioned a moment ago, you have this accident in November. They don't have insurance. Okay. Lawsuits were filed. And before the judgment was entered, the husband and wife transfer their land to their kid. So it's painfully obvious what they're doing. Right? It's painfully obvious they're transferring this to avoid a judgment. Both sons knew about this accident. They knew the father had no insurance. Right? There's no mystery about what happened here. But what makes this case complicated is this. It's only fraudulent if the creditors could have reached Blackacre in the first place. Let me say that again. It's only fraudulent if the creditors could have reached the property in the first place. If the creditors couldn't reach the entirety of the property, then they had no claim against it. And therefore, it's not fraudulent. And therefore, the transfer is valid. So the difficulty of this case is proving that the creditors could have reached it in the first instance. Okay. Now, the wife died, but that doesn't make any difference, right? After the wife died, the husband, would have gotten in fee simple, but that's totally irrelevant. What matters is the state of the property at the time of the tort, right? At the time that this thing happened, could the creditors have reached the entirety of the property? Okay? Everyone understand the facts. They're a little bit tricky. So, Jeremy, let me ask you this question. At common law, under the doctrine of coverture, right? Pretend we're back in the Middle Ages, and the husband engages in a tort, and the plaintiffs want to seize his land, and he owns it with his wife. Under the doctrine of coverture, could the plaintiffs seize the land?
I would say yeah, because he's responsible.
Yes. So you're right. So under the doctrine of coverture at the common law, right, if there was never a Married Women's Property Act, the creditors could absolutely reach the land. Why? Because the husband owns it. This entire fiction of the wife having a share is a fiction. It's not real. Okay? But the Married Women's Property Act changes the situation. It changes the situation because now the wife, who is not involved in the tort, has a separate claim here. And the wife may claim that, hey, wait a minute, I had nothing to do with this tort, therefore I'm going to block this sale. I'm going to block it because I did not engage in this tort, and you can't reach my, joint interest in this property. Everyone get that? Yes, Sarah?
On the final, if you say we're in a common law jurisdiction, are you wanting it to be the pre-agreement?
I think it's safe to say, and the notes after this case make clear that as of today, virtually no state in the union employs this approach. So I suppose if I say, let me put it this way, I would make clear if there's a marital issue that you're not applying common law coverture rules. It'll be pretty clear. I'll say common law property, community property rules as applied in Texas today, or something like that. I'll make this very clear. I'm not going to ask you to apply the doctrine of coverture.
Okay.
Does that make it clear enough?
Yeah.
I may say common law, but I do not want you applying the doctrine of coverture. That has not been in effect in any state, in 130 years or something. Yeah.
So the Married Women's Property Act, does that fall within coverture, or is that like?
No. The Married Women's Property Act is it's been in effect since what, 1830, 1840 in Texas, like 100, however many years it's been. So that is the regime which you'll be working under. Assume, and if I don't say it, I probably will, but assume that a Married Women's Property Right Act is in effect. But even so, the court's divided over how to interpret the effect of the Married Women's Property Act. And there are these four categories of states. Okay? So let's just walk through these. Is your hand up?
Yeah, I have a quick question.
Yeah, go for
Under
it.
the Married Women's Property Act, she can veto a sale, but can she also veto if the husband wants to lease the property to someone else?
Say that question one more time, please.
If the husband wants to rent the property to someone else or lease the property, can she also veto that? Or
Well, wasn't that the case we did last week with the walnut trees? That was a joint tenancy. It wasn't tenancy by the entirety. And the court in that case held that the husband could lease his share, and the lease did not destroy the unities. So I don't think she could stop a lease. But the question in that case was, if there's a lease, does the wife get a share of the rent money? And the answer was yes, the wife gets a share of the rent money. Make sense? So I saw another hand somewhere. No? All right, Crystal? You want to walk me? So let's walk through these four groups of states, right? What was this first group of state, this from Massachusetts, Michigan, and North Carolina? How did these state courts interpret the effect of the Married Women's Property Act on these tenancy by the entirety?
Basically, the act had no effect on tenancy by entirety.
Yeah.
And the husband still controls, and the wife had no share, no say.
Very good. Okay, so this first group of states, right, effectively said this Married Women's Property Act does not change anything. The husband still has complete dominion and control over the property. It's in a note afterwards, these three states have abandoned this doctrine. So even though perhaps in the 70s, whenever this case was good law, it's no longer good law. So there's no state in the union that still applies the coverture doctrine. That is long since dispensed with the world. In fact, if you'll study in con law as well, a number of cases concerning the Equal Protection Clause and what's known as intermediate scrutiny for gender discrimination, Throughout the 1970s, a significant number of these sorts of laws were invalidated as unconstitutional. So, for example, in the case of, was it Reed versus Reed, Idaho had a statute that said if there's any sort of dispute between a man and a woman over who becomes the executor of property, you choose the man. You know, there are various sorts of these presumptions in the law built in, and the court invalidated that. And there were other similar cases from the 70s and the 80s. Okay, Jamie, you want to tell me about the second group?
Sure. It says the interests of the debtor, spouse, and the estate will be sold and levied upon for his or her separate debts, subject to the other spouse's contingent right of survivorship.
Okay, so explain to me in your own words what that means. It's good. It's easy enough to read, but you got to explain it in your own words. Yeah. I'm really sorry about that. It's a heavy book too.
Well, the way I understood it was they can sell just the debtor spouses.
Good. You know, keep going. Keep going.
They can only sell
I
the
point.
debtor spouses interest in the property, but that would somehow still leave untouched the other spouses.
Right. So think about it this way, right? What this effectively does in this second group of states is it treats a tenancy by the entirety similar to a joint tenancy, right? In this regard, a creditor can attach the share of the debtor. So say the husband gets into a debt. The creditor can then attach the husband's debt. However, that does not affect the wife's right of survivorship. So this is a situation I think Jael asked me a couple minutes ago, right? The bank comes in and takes over the husband's share. Wife's share is just fine. Husband dies. Wife's survivorship kicks in, the bank loses everything. Or the wife dies first, the husband gets fee simple, and the bank takes everything the husband owns. So in this second group of states, it's effectively treating the tenants by the entirety similar to a joint tenancy, because they can get a share, but they do not cancel out the right of survivorship. Okay, and this one's actually closer to what the dissent would like, I think. Right, the dissent wants each share to be alienable or to be sold. Okay, you want to, Sean, you want to tell me about the third group, which includes, by the way, if you notice, all these 4 states, none of these are community property states like Texas, because there are different rules that apply for married property, which we'll talk about next week. But you want to tell me about the third group, please?
The attempted conveyance by any of the spouses is void, and that the estate cannot be subjected to separate debts of only one spouse.
Okay, what does that mean in your own words?
So I guess the creditor can't attach to a property for just the debts of one spouse.
Well, okay, so but give me the why. Why can't the creditor attach just for one of the spouses?
Because they each have the right to reject the sale.
Under this approach, are there separate claims, or do the husband and wife have one claim for the entirety of the land?
There's separate claims.
No. Under this approach, how are the husband and wife viewed as owning the land?
As one person.
Bingo. Because the husband and wife have one claim, if a bank has a claim against just the husband, they can't reach Blackacre because the husband doesn't own Blackacre by himself. He has no independent claim. Okay. This group 3 is how you probably understood the tenancy by the entirety from last week, right? They have this complete, wholly unified claim. And indeed, this is the majority view, and they just count the number of states, but it's the one that Hawaii adopted.
Can you repeat that one more time? I'm sorry. Because husband and wife have one claim that they can exchange.
A bank has a claim against the husband. That means the bank can get any of the husband's property. The husband does not own Blackacre by himself. He owns it with his wife jointly. It's together. So there's no way a bank can attach the husband's claim. They can't, unlike group 2, they can't pluck out just the husband's claim from Blackacre because they own it jointly. Right? I shouldn't use jointly, it's the wrong word, but they own it together. Everyone understand that?
So they both run, the husband and wife both run up separate debts. And
Look, I mean, so under the third group, right?
Right.
If the only asset they have is held jointly, and the husband and wife run up separate debts, banks can't touch it. I mean, this is actually a point that dissent makes. I think it makes a point well. If we want to talk about equality, right? If women can gain the benefits, they should also be able to gain the detriments, right? So if women now have the right to own property in their own right, they should not be able to avoid creditors for the exact reason that Hunter just said, right? They shouldn't be able to avoid this, right? You get the benefits of owning property, but this shields them from the detriments, from the liabilities.
If the wife has debt and the husband has different debt, but then those creditors sell it to one creditor, does that change anything at all?
No. Because it's still, there's no property owned by just wife. There's no property owned by just husband. It's only the jointly property. So long as a husband and wife don't sign a letter together, that property is safe. And indeed, this is not so crazy. There are actually some notes after the case which discuss bankruptcy law. And in most, I think under virtually every jurisdiction, if a person declares bankruptcy, the home may be exempt. So the law does put a special premium on the home owned by a family. They protect that more than other things. But Hunter's point is well taken. This does allow a husband and wife to run up separate debts. Now, if you're a bank and you see that Jane, her only asset is Blackacre, which is owned jointly with her husband, you're not giving Jane the mortgage unless they both sign off, right? So banks aren't. I mean, well, maybe, they know what they're doing. So they're not going to give a loan to someone whose only asset is beyond their reach. They'll make the husband and wife both sign it, and if they both sign it, then they can absolutely attach the property. But there's a different issue with torts. So, Barvar, how is this different with torts? Right? Why is this different than a bank choosing who to give a loan to? What's the key difference here with a tort? With a loan, right? The bank knows we're not going to give a mortgage just to wife. We're going to have both of them sign it, right? Because they own the property jointly. Why does that lesson not apply for torts?
Why are you not liable for your husband's torts?
Banks can manage the risk.
Yes.
Because they know in advance if their property is owned jointly that both husband and wife have to sign off on it. Why does that lesson not apply in a case like this about torts? This is actually a point mentioned by the dissent. Why is a tortfeasor not in the same position as why is a victim of a tort not in the same position as a bank in terms of managing this risk?
Well, there's a difference between they don't get to choose.
What do you mean they don't get to choose? Exactly right.
They, like I said, they're 64 days. You can't choose what the other tort. You can't choose what they're doing.
Yeah. So this is the difference, right? If you're a bank, you know not to give a loan just to the wife. You know to give the loan to the husband and wife together. If you're in a car and you get slammed by a married couple, you didn't pick them, right? You didn't pick your tortfeasor. You didn't pick your destructor, so to speak. Ghostbusters, right? You don't pick them. So therefore, there's a risk that when you get injured by someone who has jointly held property, under the regime in this third group, you can't then go after the tortfeasor simply because you didn't know in advance. Right? You can't get a waiver saying, hey, if you guys hit me in your car, I get to go after both of you. So this group 3 virtually makes it impossible for victims of torts to go after married couples if the only asset they have is property. Okay. The group 4 is similar enough to group 2 that doesn't matter, but there are separate claims that can be alienated. Yeah. The rules for bank accounts are somewhat different. But I think, give it for a second. Yeah, I think actually, if there's a jointly held bank account and both husband and wife are depositing money in it together, I don't think a victim of a tort could reach that under this sort of regime. Again, if you're noticing, a lot of this is about how to shield your life from creditors. Virtually all these rules developed to make it harder to sue. Okay, so the court. Oh yes, go ahead.
So you said they can't go after real property, but what if they have two houses and only live in one? Are both of them protected or just the one that they live in?
Under the third zone, under the third grouping of cases, if they're both held as a tenancy by the entirety, the answer is the same. The answer is the same. Although, I mean, the book notes for purpose of federal bankruptcy law, you get a homestead exemption, which is generally one house. You don't get your vacation house is not safe from creditors under federal bankruptcy law. So the court holds that they adopt the third group, that they view the husband and wife as one unit. And because the Sawadas only have a claim against the husband and not both of them, the Sawadas cannot collect the jointly held property. Therefore, because they could not collect from it, the conveyance was not fraudulent. And the sons were now able to hold the property without the banks reaching it. Any questions in the majority opinion? Lindsay, what did the dissent say?
The dissent said basically that the Married Women's Property Act made the spouses equal, and so that wasn't really fair in a way to treat them all that way.
Well, why is this not fair?
It's not fair because the wife, because both the husband and the wife equally own the property, and so the wife should also have the disabilities.
Okay, what do you mean by that? I think I mentioned before. What does it mean the wife would also have disabilities?
So like the wife gets equal access to the property now under this, but also if there's something that negatively affects the property, the wife should also.
Good, very good. So look at it this way, right? Under the old common law approach, if a woman wanted to get a loan, right, by herself, she couldn't because she had no assets on which to take a loan. The dissent says, wait a minute, we have this Marital Women's Property Act, right? Let's imagine a different case. What happens if the wife wanted to get credit on her own, not from her husband? The wife should be able then to mortgage her share in the jointly held property. But by holding that you really need both keys, right? You need the husband and the wife to sign off on a mortgage. It makes it impossible for women to have any sort of credit on their own. So what the dissent says is, even though the majority opinion has this nostalgic vision of a husband and wife together, jointly owning their property, making these decisions together, he said this Marital Women's Property Act was meant to create women with their own stature and their own ability to obtain credit from their interest in jointly held land. Okay. The court says this should be what they call a path to equality. So the dissent would have found that the husband and wife had separate shares, as if it was a joint tenancy. Therefore, the conveyance was fraudulent, and the dissent would have set it aside. Okay. So any questions on the Sawada case? Yes.
I have a question about the notes after the case.
Sure, I can do that. Glad you read them.
Well, it's primarily about the civil asset forfeiture.
Okay.
I was just wondering, what party is actually going to have to go in front of the court if the tenancy in the entirety? What party is going to have to go in front of the court and argue that the property is not being used for a criminal purpose?
So you want to tell your classmates what civil asset forfeiture is? Because I suspect most of them didn't read the notes.
It's
I know,
how
it's okay.
police make money off of criminals.
Be a little bit less, a little bit more precise.
So if authorities suspect that some kind of asset is being used for criminal means or something is a product of criminal enterprise, they can take it and then you have to go to court and you have to argue that the property in question or the money in question is not being used for a criminal purpose. It shifts the burden onto, it's not presumption of innocence, it's presumption of guilt.
Okay, very good. So I'll use an easy example, a very famous one. So there was a grandmother in Philadelphia, and her teenage grandson lived with her. And one day, her teenage grandson was dealing drugs on her porch. And the grandmother had no idea. She had no idea what was going on. The police show up. They arrest the grandson because he's dealing drugs on the porch. Then the police in Philadelphia institute something called civil asset forfeiture. What they basically say is that the house was being used in the commission of a crime. Therefore, the state will seize the house as an instrumentality of the crime, and they'll put the house up for auction. So grandma loses her house because her grandson is an idiot and is dealing dope on the porch. Excuse me. The proceeding to challenge this is, as Hunter said, the burden is on the property owner to assert that his property was not being used in the commission of a crime. These proceedings are very slanted, and it's very difficult to prove that because, indeed, the crime was being used. This often happens where, say, someone is driving someone else's car, and that person has drugs on them, and they take the person's car who had nothing to do with it. So Hunter's question was, who gets to argue in the case of a married couple? I suspect either one would have to make the argument, but these are proceedings that, generally speaking, property owners lose. So the hearing will not go very far. Other questions? Yeah.
What is the burden of proof for that? Is it preponderance or beyond?
Oh God, I don't remember. Yeah, I think he's right. I'm not 100%, but I think it's preponderance. Because it's a civil proceeding, it's not a criminal proceeding, so it's basically more likely than not. So yeah.
If they were joint court features with the entirety still shared.
That was Sarah's question a few minutes ago. Yeah, I mean that was her question a couple minutes ago, right? So if they were both jointly responsible for the tort, then I suppose then the judgment would be against both of them, in which case you could reach the tenancy by the entirety. Yeah. In this case, the wife was a passenger and she wasn't involved in the accident at all. Okay. Again, hopefully at 11, I can see you all at the 6th floor library for the event with Justice Busby. You get a few minutes now to walk up. Have a wonderful day. I'll see you soon, and enjoy.